Lawyer A. Sri Murugan said the Attorney General had the discretion whether to prosecute suspects under the new fake news law covering COVID-19 and the state of emergency. He said the Attorney General, who is also the public prosecutor, could rely on the Penal Code or the Communications and Multimedia Act to file charges against those accused of spreading such false news. Existing laws passed by Parliament should not be sidelined just because an ordinance to check the spread of false news has been enacted, Sri Murugan said in response to the hefty punishment imposed under the ordinance against those who create, publish or distribute fake news. Under the new fake news law, offenders may be fined a maximum of 100,000 ringgit, jailed up to 3 years, or both under the ordinance if found guilty, while those who pay for the creation of such fake news will face harsher punishment with fines of up to 500,000 ringgit or a jail term of 6 years, or both. The courts may also order those convicted of an offence to apologise to those affected by their actions. Failure to do so may result in another fine of up to 50,000 ringgit, a jail term of under a year, or both. However, Sri Murugan said Section 2331A of the Communications and Multimedia Act that carried a fine of up to 50,000 ringgit or a jail term of up to 1 year, or both, could be invoked against offenders for improper use of network facilities. He said the prosecution could also rely on several provisions in the Penal Code, like Section 505 for making statements conducive to public mischief, which carries a jail term of up to 2 years, or fine, or both.